So I want you to just imagine a total nightmare scenario for a second.
Oh, boy. Okay, lay it on me.
Right. So you ran a small business for, let's say, 15 years. You poured your heart, your soul, your weekends, basically your entire life into this thing.
Yeah, the classic small business grind.
Exactly. And to keep it alive, you put your own name on the line. You signed, personal guarantees on the equipment loans, the commercial lease, the credit lines, because, that is just the price of admission to keep a business breathing.
Right. Oh, absolutely. You basically have to leverage your personal life to build the corporate one.
Right. But then the music stops. You make the really agonizing decision to just close the doors. The business is totally gone.
Yeah.
But you are still entirely exposed. And today, we're doing a deep dive into how a single word, literally one single word, hidden inside a recent bankruptcy ruling, is finally offering a way out of that exact nightmare.
It really is a nightmare, too, because, the physical manifestation of all that work might be gone. The storefront is dark. But those liabilities, they're anchored directly to your personal life now.
Yeah, that corporate shield just completely drops.
Exactly. The corporate shield drops, and the creditors who used to call the company, well, they start coming after you personally. So you're sitting at the kitchen table, staring at a stack of demand letters. And historically, when you went looking for a legal lifeline in that situation, you were basically told the door was slammed shut.
Which is just terrifying. So to guide us through this, we are pulling from a really insightful piece of source material by Philip Zagati.
Yes, great source.
He is a JD and a CPA, and he's the founder of North Star Law Firm down in Houston. And Zagati shares his direct, on-the-ground experience helping clients actually navigate these crises.
And the mission of our deep dive today is to break down this massive recent legal shift that he highlights. It acts as a hidden lifeline for former business owners.
A lifeline that, frankly, a lot of people don't even know exists.
Exactly. It's a path to restructuring debt that many lawyers, even practicing attorneys, still incorrectly believe is completely closed off.
Okay, so to really appreciate the breakthrough that Zagati and his team at North Star Law Firm are sharing with us, I think we first need to look at the brick wall that former business owners used to just, smash into.
Oh, yeah. The old strict reading trap.
Right, because anyone familiar with the business world probably knows about Subchapter V, right?
Yep, Subchapter V. Congress created this specific track of bankruptcy a few years ago, and the whole point was for it to be faster, cheaper, and just generally friendlier for small businesses.
Right, it allows owners to actually keep their equity while they figure out a payment plan.
Exactly. It was meant to be the antidote to the regular, massive corporate bankruptcy processes, the ones that just bleed mom and pop shops totally dry with legal fees.
Yeah, when Subchapter V came out, everybody cheered. It sounded like the absolute perfect safety net. But there was a tripwire hidden in the eligibility requirements.
A huge tripwire. So to get into this friendly lane, the law requires you to qualify as a quote-unquote small business debtor.
Okay, makes sense.
Right. And the statute defines that as a person engaged in commercial or business activities.
Engaged in commercial or business activities.
Yes. And for years, a whole camp of courts applied a really strict reading to that one single phrase. They interpreted it to mean you had to be operating a business actively on the exact day you file for help.
So wait, if you were, keeping the lights on and selling 1 cup of coffee a day just to maintain appearances, you were safe.
You got it. But if you did the responsible thing and actually shut down the looting enterprise so you wouldn't rack up even more debt,
then the court just looks at you and says, you are locked out. That is wild. It's like the Coast Guard telling you that you only qualify for a life raft if your ship is still actively sailing. But since your ship just sank, you're out of luck.
That is a perfect analogy. That's exactly how it worked. And judges preferred that strict reading because, honestly, it was administratively easy.
A bright line rule.
Right. Judges have packed dockets. So a simple rule like, are the doors open, yes or no, is just so much easier to apply than having to dive into the messy reality of a business wind down.
But the result of that laziness, or I guess administrative efficiency, is just disastrous for you.
Utterly disastrous. You could have millions of dollars in debt that originated entirely from a defunct business. But because the physical doors were closed, the courts told you to go use the incredibly expensive corporate process or just liquidate everything you own.
It essentially punishes business owners for mitigating damages.
Yeah.
It forces people to play a weird game of chicken with their own failing companies.
Yeah. Exactly. And that harsh reality, that exact friction, is what triggered a pivotal court battle known as the Stevens case. Zagati highlights this as the moment the game totally changed.
Okay, so talk to me about the Stevens case, because this is where that single word comes in, right?
Right. So the Stevens case tackled that strict reading head on. You had this business owner who owned 100% of a company that had been closed for years.
Closed for years, okay.
Yeah. And the owner was left holding the bag on massive personal guarantees. The creditors were relentlessly chasing him. So he filed for this streamlined small business reorganization track to try and survive.
And I'm guessing a creditor immediately tried to get his case thrown out.
Oh, immediately. Using that same familiar, strict argument, he's not operating a business, so kick him out, give us his assets.
But the judge in the Stevens case did something different. They actually looked closely at the mechanics of the law.
Yes,
Well-
because Congress wrote the word activities. They did not write the word operating.
And that linguistic distinction is the hinge this entire Lifeline swings on.
Exactly. If Congress wanted to limit this protection to people running active businesses, they could have easily written engaged in operating a business. But they deliberately chose a broader word.
Activities.
Right. So the judge established this groundbreaking perspective on the lingering afterlife of a company. When you manage personal guarantees on debts from a closed business, when you negotiate with those creditors or defend lawsuits, that work itself is a commercial activity.
Okay, hold on. Let me just play devil's advocate here, or push back a bit. I struggle to see how a personal guarantee is anything but personal.
Okay, fair question.
I mean, if the LLC is dead, the corporate shield is gone. It is just me owing money to a bank. Why would the court pretend it is still a commercial issue instead of just a personal, consumer finance problem?
Well, you have to look at the origin of the obligation.
Yeah.
You didn't incur that debt buying a flat-screen television for your living room, right?
Right, okay.
The obligation originated from commerce. Dealing with commercial creditors, vendors, and landlords is inherently a commercial negotiation. It doesn't matter who is on the other side of the table now. It carries a commercial character.
So because the underlying DNA of the debt is business-related.
Exactly. Because of that DNA, the Stevens judge declared we shouldn't use a strict "are you operating" test. We should use a totality-of-the-circumstances test.
Totality of the circumstances. It's like the difference between looking at a single star, like is the storefront open,
Yeah.
and looking at the whole constellation.
Oh, I like that. The whole constellation.
Yeah, like the court is finally looking at the whole sky. The lawsuits, the lease unwinding, the vendor calls. They are evaluating if the entire picture still looks like business.
That constellation metaphor is the perfect way to understand the shift. Viewed as a whole, the judge ruled that managing the messy afterlife of a business counts. The flexible approach won out over the old strict reading.
Okay, so since the courts traded that rigid rule for this broader umbrella of activities, I think we need to know what actually fits under that umbrella.
Definitely.
Like if you are the person staring at the demand letters right now, you want to know what stars actually make up that constellation.
Right. And Zagati is applying this day-to-day in Houston, where the local courts have fully adopted this broader Stevens reasoning. So through his firm, we actually have a really clear picture of what the courts consider legitimate commercial activity now.
Okay, let's list them out. What's the biggest one?
The biggest one is actively managing those personal guarantees on business debts. If you are fielding calls, corresponding, negotiating with banks or landlords regarding those guarantees, you are engaging in commercial activity.
Okay, so just fighting the debt is commercial activity. That makes sense. What else?
Another major factor is collecting accounts receivable.
Oh, interesting. Even if the business is closed.
Yes. Even if it's completely closed, there's often money still owed to it. If you are actively working to collect those outstanding funds, you are acting as a commercial entity trying to settle the books.
Got it. And I imagine litigating to resolve business obligations also makes the list.
Absolutely. Defending against lawsuits from business creditors is heavily treated as a commercial activity.
Okay, what about like side hustles or consulting?
Yes, consulting or doing freelance work in the exact same field as your closed business also helps build that constellation. Like, say you closed a plumbing company, but you are still taking independent contracting work in the trades. The court sees a continuation of business activities.
Okay, that makes a lot of sense. And finally, what about just the messy act of shutting down?
Carrying out substantial wind-down work heavily, heavily tips the scales.
Yeah, because wind-down work is never just turning the key in the lock and walking away. It involves liquidating leftover inventory, unwinding multi-year commercial leases, closing out complex vendor accounts. I mean, it is a massive administrative burden.
Exactly. And if that work is substantial and ongoing, the court looks at the totality of those actions and confirms, yep, you are still engaged in commercial activities.
Okay, I am trying to picture the boundary line here, though. Let's say I just have one tiny star. Say I have walked away from the business world entirely. I am working a regular W-2 job in a totally different industry, and I am just sitting at home paying off my personal credit card from grocery shopping.
Right.
Does that make a constellation? Does that count?
No. Passive personal financial management with no connection to the defunct business does not qualify. If you have severed all ties, you aren't litigating, you aren't collecting, and your only debts are consumer debts, you will have a very, very hard time fitting under this standard.
Because there's no business DNA left in your actions.
Exactly. The judge looks holistically at your active business-related entanglements. It is a heavily fact-specific inquiry.
Okay, that makes sense. But if this is such an amazing lifeline, why doesn't every defunct business owner use it? I mean, the courts can't just be handing out magic erasers for bad debts. There has to be a catch.
You're right. There are limits. The bankruptcy code is completely obsessed with balance. It is always trying to balance giving the honest debtor a fresh start with ensuring creditors get whatever fair repayment is actually possible.
Right. So no magic wands.
No magic wands. The system imposes what Zagati calls honest limits. You have to pass a pretty strict financial stress test to walk through this newly opened door.
Let's talk about that stress test.
Right.
The first barrier is the debt cap, right?
Yes. The current limit on total debt to qualify for the streamlined small business process is about $3.5 million. Specifically, it's $3,424,000.
$3,424,000. That is very specific.
It is, and that oddly specific number is actually a great example of how the bankruptcy code functions. The limits aren't static, they are periodically adjusted for inflation. It shows how the law breathes and updates.
That's fascinating. But we need to address a massive point of confusion here because I know people often hear they can have up to $7.5 million in debt and still qualify.
Oh, yes, we have to clear this up. That confusion stems from a legislative roller coaster over the last few years.
Because of the pandemic, right?
Exactly.
Yeah.
During the pandemic, under the CARES Act, Congress temporarily raised that cap to $7.5 million to help struggling businesses. But, and this is crucial, that higher historical cap expired.
Okay, so it's gone.
It's gone. Now, there is bipartisan legislation pending in Congress right now, the Bankruptcy Threshold Adjustment Act of 2026, that would restore the $7.5 million cap.
Okay.
But we must strictly emphasize that the higher number has not passed. It is not current law. As of right now, if your total debts exceed $3,424,000, you cannot use this specific small business process, period.
Wow. Okay, so relying on pending legislation is a dangerous game when creditors are actively trying to seize your assets.
Exactly. Don't bet your house on a bill that hasn't passed.
So the second limit in the stress test is the debt ratio. You mentioned the DNA of the debt earlier.
Yeah.
The court cares deeply about the origin of your debt, right?
Very deeply. At least half of your total debt must be business-related, not consumer debt.
Okay, so if my financial distress is primarily caused by, say, running up personal credit cards for vacations, a massive mortgage on my family home, and maybe paying for my kids' student loans.
Then you don't qualify for this specific business lane, regardless of the fact that you used to run a company. The math must prove that 50% or more of the burden is commercial in nature.
Got it. Okay, then we get into the actual mechanics of the deal you were making with the court, starting with planned feasibility. Because you can't just walk in, point to the Stevens case, and ask to magically restructure your debt.
Right. You have to prove to the court that you have the actual income or assets to fund the reorganization plan you were proposing. You can't promise money that doesn't exist.
So if I have zero income, zero business prospects, and zero assets,
then you aren't a candidate for this reorganization because you can't feasibly pay anything into a plan. The court won't approve a fantasy, and this ties directly into the final limit, which requires committing your projected disposable income.
Right. So in a typical plan under this process, whatever income you have left over after necessary basic living expenses, that has to go to the creditors, right? For how long?
Usually for 3 to 5 years.
Hmm.
The underlying logic here is that you are exchanging your future disposable income for immediate protection and a structured, survivable path forward.
So the creditors do get something.
They get something, usually less than full payment, but certainly more than they would receive if you just liquidated everything in a chaotic panic.
Okay, so this isn't a get-out-of-jail-free card. It is a payment plan structured by a referee. You still have
Yeah.
to pay,
Yeah.
but you get to do it on survivable terms over several years instead of having a massive immediate judgment just absolutely ruin the next decade of your life.
Exactly. It's about survival. But, knowing the theory behind the Stevens case and the strict limits of the law, that only matters if you can actually apply it.
Right, because if you are a small business owner currently buried in demand letters, you need a plan. And Zagatti lays out a very clear step-by-step action plan based on what his team at North Star Law Firm actually sees working in the trenches.
Step 1 is facing the music and running the math.
Ugh, the scary part.
The scariest part. But you have to get a crystal clear picture of your debts. Add up the personal guarantees, the judgments, the vendor balances, the credit cards. You need absolute certainty that you meet that precise $3,424,000 limit and that you clear the 50% business threshold.
Okay, and once the math checks out, step 2 is starting to document your day-to-day activities.
Yes. Because the court uses that totality of the circumstances test, the burden of proof is actually on you to show you are still entangled in commercial wind-down work.
So I can't just walk into court and say, hey, I'm handling business stuff, trust me.
Definitely not. A vague claim will not survive scrutiny. You need to log every time you negotiate a personal guarantee, every lawsuit you defend, every old account you try to collect. You need a detailed record of your constellation.
But all that documentation is completely useless if you hand it to the wrong person. Which brings us to step 3. Finding an attorney who actually understands this post-Stevens legal landscape.
This is so critical. A major hidden risk here isn't just the aggressive creditors, it is consulting an uninformed lawyer.
Because the law is so dynamic, right?
Exactly. And Subchapter V is still a relatively new section of the bankruptcy code. Not every practitioner tracks every single nuanced shift in case law. Many lawyers might look at your situation, see that your physical doors are closed, and just tell you that you have no options.
Simply because they are still operating under the old strict reading.
Right. They don't even know the door has been opened.
It's terrifying to think you could lose everything just because your counsel hasn't read the latest precedents.
It happens all the time. So if you are told this option isn't available to you solely because you are no longer operating the business, that is a massive red flag. You need a second opinion from someone who understands the broader activities standard.
And the final, and perhaps most urgent piece of advice Zagatti offers is step 4. Act proactively.
Yes. The legal machinery works best when deployed while you still have options and breathing room. Because the moment you officially file for this protection, an automatic stay goes into effect.
An automatic stay. Explain that really quickly.
It acts as an immediate shield, legally stopping all collection activity, phone calls, lawsuits, everything.
Wow. And this is but it cannot magically travel back in time, right?
Nope. If you wait until a creditor has already successfully seized your bank accounts or put an ironclad lien on your house, the automatic stay might stop future damage, but it can't always undo the devastation that has already occurred.
So you cannot wait until the sheriff is literally knocking on your door.
You really can't. The entire landscape for small business owners whose companies have closed is just fundamentally different today. The old trap of having to artificially keep a failing business on life support just to qualify for legal protection, that has been dismantled.
It has been replaced by judges who are actually willing to look at the totality of your circumstances. As long as you know how to properly frame and document your ongoing activities, especially the management of those terrifying personal guarantees, you have a viable path forward.
You absolutely do.
So, if the mechanics of this shift resonated with you, or if you just need to understand the broader financial and legal strategies available to protect what you have built, we highly recommend checking out more of Philip Zagatti's work.
Yes, bringing that dual perspective of both a JD and a CPA is so valuable. He has actually co-authored 2 incredibly practical books written specifically for non-specialists.
Right. Those books are Taxed, which is a comprehensive guide to tax defense and resolution, and Trusted, an essential guide designed for trustees.
Both are just fantastic resources for navigating really complex financial obligations without getting completely lost in legal jargon.
And if you want to learn more about the specific, on-the-ground work his team does to help business owners navigate these complex intersections of tax liability and bankruptcy, you can visit his firm's website directly at htx-legal.net.
The system can adapt to reality, but you have to know the new rules to actually play the game. The overarching lesson from the Stevens case is that labels matter less than actions. The courts have finally recognized that shutting a door doesn't erase the commercial reality of the work left behind.
It really makes you wonder, if the legal system can completely redefine what business activities means, broadening it to include the messy, lingering afterlife of a closed company, what other closed chapters of our financial or professional lives might actually still be open for negotiation if we just look at them through a different lens.